Welcome to the Licensed Ally Expert Series, where industry experts provide helpful insights and information to help you stay up to date on relevant issues for mental health professionals. I'm your host, Dr. Chris Stack, licensed psychologist in California. With me today is Dr. Elijah Morrow. Dr. Morrow is a licensed psychologist in California, as well as a licensed attorney in California. Thank you for being here, Dr. Morrow.
Thank you for having me, Dr. Stack.
Dr. Morrow will be leading a discussion today on the psychologist's duty to warn within the context of malpractice. This discussion can count as continuing professional development hours for licensed psychologists in California under the self-directed learning activity. It can also count toward the laws and ethics hours requirement. After the discussion, instructions will be provided on how to log these hours onto licensedally.com. Dr. Morrow, please take it away.
So we're going to be talking about the duty to warn / the duty to protect. People call it slightly different things. And it's a unique theory of malpractice within the different legal theories that you could bring against a psychologist. In order to understand it, we kind of have to start at the basics, and then we'll go through a little bit of the case law that's California specific. I've been on both sides of this. I haven't been sued for malpractice, thankfully, but I have been a litigator. I brought and litigated malpractice against other physicians, not psychologists. So I'm a little bit aware of the things that an attorney looks for, which is very different from what a psychologist on the ground might do in front of a patient. So two things off the bat. One, that this is not legal advice. I've been engaged in the practice, but there are people who specialize in malpractice defense for psychologists. And I might be able to go through some of the case law, but sometimes things fall out of disfavor with judges long before they're overruled. So simply because there's a good rule of law in the books, that doesn't mean that practically it's going to be something that anybody's going to rely on very often. And those sorts of nuances and how the law applies to the facts of your case are going to differ quite a bit, and you need somebody who's very experienced in this area to protect you. So don't take this as gospel. If you do have a malpractice suit against you, I would encourage you to go speak with somebody who practices within the malpractice defense for psychologists. The second thing is that nobody can stop you from being sued. I can give you, you can get stopped from being sued successfully, though. Anybody can bring a suit. I brought numerous. They're not that hard to file. But whether or not somebody can actually carry a malpractice suit and get money back from you for damages, that's going to depend on how well you adhere to the standards of practice. So knowing what the standards of practice are and how the courts have interpreted it is very important for making sure that your practice aligns and protecting yourself from some of the liability. So let's start at the very beginning about what malpractice is. Malpractice is a very broad umbrella, which just means suits brought against somebody who's acting as a professional. Very broad. That can encompass many different legal theories. For example, let's say a psychologist sexually touches one of their patients. And that can be an act in negligence because there's a standard of care that's codified in our ethics code, as well as some statutory codes. And when they cross that boundary, they engage in a breach of their duty. But it can also be battery. It's an impermissible touching, which is likely to cause reasonable offense to the person who's being touched. So there's two different theories of liability that somebody can bring. There's also criminal codes, which can apply to that as well. So you can have multiple theories of tort liability, as well as criminal liability for the same action. The dominant one, though, in malpractice is negligence. And duty to warn falls under the theory of negligence. And in order to understand how it's different, we have to kind of go through what negligence is and why attorneys kind of gravitate towards that one as a theory of liability. So broadly speaking, there are four elements that you have to prove in order to prevail in a case for negligence. It's a duty, breach of that duty, causation, and damages. If you're able to prove all four in preponderance of evidence, then you're able to recover monetary damages against the person who breached the duty. let's go into each of these elements a little bit more specifically. So duty. So you have to have a special relationship with the person in order for there to be a duty. Let's imagine that there's a city. It's built on a beautiful lake, and they have a lot of tourists come swim in the lake. And in order to protect the tourists and make sure that everyone feels safe, they hire a lifeguard. Now, the lifeguard, while he's on duty, has a special relationship with the people in the water. He's there to protect them. That's the whole nature of his job. There's a special relationship between the lifeguard and the people that he's there to protect. So if he were to fall asleep, or I don't know, run off from his shift for long periods of time and somebody were to drown, well, there's that special relationship there where he was supposed to be doing something and he didn't do what he was supposed to do. So that's the special relationship, and it doesn't always exist when we think it does. A very popular bar exam question is a scenario similar to the lifeguard. Let's imagine Michael Phelps decides to visit this beautiful lake. And he's on the side of the lake. He's looking out over the water. And he's got an extra life jacket with him, and he's feeling limbered up and ready to swim. And he looks out and he sees somebody drowning. Now, this man clearly could swim out and save this person. And if he doesn't, there's not a suit for negligence there. He does not have a duty. He's capable of helping the person, but he doesn't have a special relationship, even though he has all these skills. Morally, the reason why this is a really good question on the bar exam is because morally, we're like, well, he should do something to help. We push against that a little bit, and that's very understandable. And morally, we can condemn Michael Phelps for not saving the person who was drowning, but legally, we could not hold him liable for negligence. Now, if he took on the special relationship of a rescuer and he swam out there, he does have a duty at that point. He can't freak out and push the person under the water and drown because he gets scared. At that point, he has the special relationship of a rescuer, which is a little bit different. But he could sit on the side of the lake and smoke a cigarette and watch the person drown, and he's not liable for negligence. Why that's important to our practice is because we have a special relationship. We have clients that come to us, and there are duties that are imposed because of that relationship. We have a duty of competence. We have duty of confidentiality. We have a duty to ensure that we are practicing within the realms of what we know and that we're doing it well and that we're documenting it and protecting the private information appropriately. So the reason why attorneys really like negligence as a theory against professionals is that that element is very easy to prove. We have a duty. Boom, that's already 25% of the way there into sustaining a case of negligence. The second one is breach of the duty. There's something we were supposed to do that we did not. And what we'll see in a little bit is the Tarasoff case. The psychologist actually took a lot of steps to protect the victim. He contacted campus police. He tried to dissuade the individual from attacking the lady, but he didn't do the thing that he was supposed to do, which was warn the victim when all else failed. So there was something that he was supposed to do that he didn't. And when we think of the term negligence, we usually think sloppy, but that's not necessarily the case. The defendant in Tarasoff was far from sloppy. He was actually very proactive, especially considering the state of the law at the time. But he still didn't do what he was supposed to do, so he was liable. That is one of the ones that is a little bit harder to prove, and what we'll talk about in the duty to warn, what constitutes a breach. Causation is where us as psychologists get a little bit of a leg up. And most of the malpractice actions are against physicians and not psychologists. And that's partly because this element is very difficult to prove. Now, I'm litigating a case against a physician who prescribed a strong dose of OxyContin to a 3-year-old with some complicated medical conditions, and the 3-year-old overdosed on the OxyContin. There's very clear causation. If this OxyContin dosage hadn't been prescribed, this child would not have overdosed. Very clear. And in the physician realms, that's much clearer the lines of causation. The classical example of the surgeon who leaves the sponge inside the patient while he's doing the surgery, and the person has physical complications because there's a sponge inside them. That's very easy to prove. Mental health symptoms are more abstract, and we only receive patients typically who come to us with symptoms that they already have. If somebody's anxious, and let's say you breach the duty of confidentiality, they're claiming that they're anxious. Well, what symptoms were there before they came? What symptoms were there because of the breach? It becomes murky, the quantification, and demonstrating that there's an increase in the symptoms or that new symptoms resulted. Causation in our profession is much harder to prove.
Yeah, that's really interesting. And so I'm trying to kind of connect the dots to actual documentation as well, and the importance of taking thorough notes to really document what you're doing and staying within your lane. I think you mentioned it earlier, is staying within your scope of practice, the modalities that you know. Maybe don't test new theories out on people that if you're not yourself well versed and well trained in it, then definitely you should not be going in that area. So you could actually open yourself up to litigation, it sounds like, if it could be demonstrated that whatever intervention you attempted failed or somehow made the symptoms worse, then you could potentially open yourself up, at least on this part, the causation aspect.
Yes. I'm going to tell one funny story about a psychologist who tried something new and got sued for it successfully. And then maybe a note of best practice. So there was a psychologist back in the 60s who tried, I think it was called primitive therapy. He had a psychoanalytical conceptualization of individuals with schizophrenia that they had significantly regressed to a very young state of age. So his theory was, well, they only understand primitive communication instead of this higher order dream interpretation and intellectualism. So what he did is he screamed at patients and he struck patients, because he was saying in his mind, I'm meeting them at their level. It's a new form of therapy. It's the only way that I can actually get through to these guys.
Wow. Wow.
So one of his patients who got struck sued him, and he was practicing this new form of psychotherapy. He probably didn't receive full informed consent, and the judge actually said, in this case, I don't need an expert to say that this was a breach and that damages occurred. It's fairly obvious.
Yeah, it's common sense in that situation. Wow, that's horrible.
Yes. You would think that it's common sense.
You would hope, yes.
Right. But then best practices, therapy and new modalities aren't necessarily a bad thing. So therapy can cause an increase in distress, particularly during the early stages while you're opening up old wounds and adjusting ways of dealing with your distress. There's often an increase in the symptom severity that people experience. And also, new therapy modalities are developed all the time. What protects you in both scenarios is the informed consent process. You should be, as part of your practice, explaining to patients that they can experience an increase in symptoms. And you should be explaining, when you're trying new therapy modalities, that this is untested, that there are these other options available that have been proved efficacious. You shouldn't try and improperly induce them, but you can try these things and you can increase symptom severity, but there's a general defense to negligence, which is an assumption of the risk. If you know about the risk and you assume the risk, then you're not liable even if there's causation. The famous example is going to a baseball game. I love baseball games. But if you sit in the outfield or further down the foul line, there is a likelihood that a baseball player will pull a pitch and it will strike you in the face. But they're not liable for negligence because if you come to the baseball game, you know that that is a possibility.
It's an assumed risk.
It is an assumed risk, absolutely. So yes, going back to documentation, documenting that you told them that there can be an increase in symptom severity will actually help protect a little bit against some of that causation. Even when causation is present, it doesn't necessarily mean that you have to be liable for the symptoms.
But this still also assumes that you're, well, at least somewhat trained in the modality that you're going to attempt. That doesn't mean you can just arbitrarily decide, I'm going to try this today. And, when you really have no formal training or no experience with it, there still is a level of expertise that's expected on your part, correct?
Absolutely.
Okay.
So going through these new processes is absolutely expected. Let's take research, for example. Going through a research process can cause individuals an increase in symptoms. However, if you're doing it, haphazardly and shoddily, and you don't have any experience in protecting patients, that's why that there's trainings required for anybody who goes through a research process and submits something to an IRB, is because you have to be fully trained, you have to have experience to do these things competently and within your scope of practice.
Excellent. That makes sense.
So that's three of the elements of negligence. The final one is damages, which means that there has to have been some sort of harm. The court is essentially too busy to rectify every single mistake. That's not what they're there for, but they are there to help people be compensated for mistakes that cause harm. So let's say, for example, you have a patient that comes to you and tells you that they are cheating on their spouse. And after they leave the session, you have further thoughts about it, and you call them at their home voicemail, and you leave them a long voicemail about how proud you are that they came and opened up about the infidelity, and you see that they're wanting to work on this issue, and you put a lot of details into that voicemail. Well, then the spouse listens to the voicemail. Clear duty breach elements met. Duty of confidentiality, you left this confidential information on an area that can be accessed. But if that doesn't cause damages, you're not necessarily going to be liable. So let's just say that the spouse comes in next session and says, you know what, I'm so glad that voicemail was left. It really opened up conversation lines between me and my spouse. We're able to work on things that we haven't for a long time. We've never been better. Technically, no harm, no foul. But like I said, the court isn't there to fix every mistake. It's there to compensate victims. Now, there is kind of like a loophole with nominal damages. Nominal damages are what you hear like somebody claims just like $1. Taylor Swift did this back in 2017 when I think it was a Denver radio host groped her. She maybe couldn't claim damages, but she didn't claim damages. She didn't say, my music career suffered as a result, or I experienced, mental health symptoms. But what she did say is that my rights were violated, and I want to make it known that to this person that that's not okay. So she received a nominal award of $1. No damages were claimed. She was still able to prove liability, but beyond that, nothing else was gained. So that's technically a loophole to that, but broadly speaking, there has to be some sort of harm that occurred.
And it's important, this is strictly from a legal perspective, because if that person, going back to the infidelity voicemail, if that person later thought about this and maybe a few months down the road decided, you know what, they should not have shared those details as a confidential issue, and then maybe they contacted the board you could be sanctioned by the board of psychology and reprimanded in some fashion. So although maybe there weren't damages met from a legal perspective, from a psychology ethics perspective, you still were in the wrong. And I hope people listening don't leave detailed voicemails because you never know who can be around to listen.
Yes.
But, yeah. So just
So
an
for the
important
sake of
distinction.
proving that one element, absolutely. And let's just say that the couple decided to go to couples therapy as a result. In that's an economic damage, even if they aren't, distressed, but for the phone call leaving the message, they wouldn't have gone to couples therapy. They wouldn't have incurred that expense. Even under that scenario, you might have to pay for their therapy.
Oh, interesting. Okay.
Yeah. So you're absolutely right. Just because somebody's not initially upset doesn't mean they won't be upset later down the line. There aren't other sanctions that could be imposed against you. It's a breach of HIPAA. There are fines associated with that, whether or not that there's harm. And there doesn't mean that there might be some other form of economic damage that you would have to pay.
Makes sense.
So, like I said, negligence is very popular among attorneys and for bringing suits against professionals. And I'll tell you why. So 4 elements, each has to be proved by a preponderance of the evidence. So 50.1% likely or greater. It's a very low threshold. And we already pretty much have 2 whenever somebody comes into our office. If it's a professional, there was a duty because there was a special relationship. And if they're upset, there's probably some form of damages. Outside of, like a certain subset of litigious people don't seek out attorneys unless they feel harmed in some sense, because litigation is a very draining process. So they're usually coming to us because they've experienced some sort of increase in symptoms, economic damages. They say, this isn't fair. Somebody has to do something about it. So usually by the time they walk into our office, we've already met 2 out of the 4 elements. The real sticking point is, like I said, the breach of duty, proving that what they did fell below what they were supposed to do, and that because of them failing to do whatever they were supposed to do, it resulted in whatever damages they're claiming.
Interesting. Yeah. I suppose just by virtue of going to see an attorney that there were some sort of damage, unless, like you said, they're just litigious people looking for quick buck or whatever. But yeah, okay.
Yeah. And I mean, any good defense attorney is going to say, there's not damages, but preponderance of the evidence, it's pretty easy to prove the fact that there was some. The usual question is not whether there was damages, but how much are the damages? How do we quantify it?
Well, I mean, you had mentioned earlier that sort of, especially on the at the onset of therapy, that symptoms could worsen. It could get. So at what point, suppose that that's what the client is experiencing, is this worsening of symptoms, and they say, hey, I'm getting damaged by this. This is doing more harm than good. I'm paying this person X number of dollars per session, so I'm losing out financially. I feel worse. I'm going to go talk to an attorney. Is there a point where we expect those symptoms to get better? And I suppose if the client doesn't wait long enough to let that treatment take effect, who determines that? And at what point is that sort of expected?
Right. Well, that's where we get to whether or not there was a breach. And typically what an attorney will do is they'll retain an expert in the field and they'll ask, hey, is what this person doing a breach of their duty? And merely because somebody feels distressed doesn't mean that you aren't practicing competently. Even in the most efficacious medications out there are a very small subset of people who experience adverse side effects that are unexpected. And even in therapy, the most competent clinicians can have cases that fail. And that doesn't mean that you breached your duty. That's just part of the inherent unknown of living in a world where there's a lot of factors going on and we can't always account for all of them. You're not expected to be perfect. You are just expected to meet the duty that you have. And as long as you're practicing competently, ethically, documenting those things, there's no breach. even if that person experienced damages.
Okay. And one of those duties is duty to warn. And I know that's sort of where we want to drill this focus down to. So can
Great
you explain
segue.
a little bit more on the duty to warn?
Yes, absolutely. So why I started out with the background of negligence is because this is a theory of negligence, but it's an odd one. It's an odd one. In order to understand why it kind of shocked the therapy world in the 1970s when it came out, you have to understand that special relationship between you and a person. So going back to the lifeguard, let's say he was asleep at his post and somebody drowned. Right? He is liable to that person's estate for him falling asleep on the job and the damages that had occurred. But let's assume that the person who drowned was a salesman, top salesman of their company, outperformed everybody leaps and bounds. The employer who lost that revenue cannot, broadly speaking, bring a suit against the lifeguard successfully because no special relationship existed. Yes, there was some causation. Yes, there was damages. Yes, there was a duty that was breached. But because the lifeguard wasn't in a special relationship with that employer, it's going to be very hard to prevail. Now, this is the duty imposed on to third parties. And this is where the duty to warn is interesting, because third parties who are not your patient may bring suit for something that you failed to do with your patient. There's some precedent for this in the law, so it didn't come out of the blue, but for the first time, explicitly, therapists were now liable to the greater public for the actions that they took with their patient.
Interesting. Okay. Yeah, is that considered, I suppose, evidence that they did fail in their duty, not just to warn, but well, no. I mean, they're not going to be held liable if treatment isn't working. Sometimes it just doesn't work. Sometimes whatever modality you're using doesn't work for that client. And so that's not where the liability is. It's if you are aware of a threat, a specific threat, and you fail to report or warn, that's where the duty failure lies, correct? Okay. I do have okay. So, I mean, I guess, how do you determine when a threat is imminent enough that now I have a responsibility to warn the appropriate people about this?
Right. So when 1976, when Tarasoff came out, there was a lot of clamor from the Board of Psychology professionals. They were very concerned about the extent of liability that could be imposed, right? Because read liberally, any failure in the treatment that causes a harm to somebody else, you could be liable for. And everybody was very concerned about that, right? Let's say you're working with an alcoholic and they fail to correct their ways, and because of that, a marriage falls apart, or they abuse their kids. Therapists were concerned, under this third-party duty that's being imposed through Tarasoff, that they might be liable, not just for failing to treat the patient competently, but also to the wife and the kids. And where does it end? The kids, the wife's friends. It opened the possibility for a lot of litigation, and the legislature actually listened to the field, and they codified it. They codified this rule into a statute, which under California Civil Code 43.92 AB, because they wanted to limit some of the potential liability that could incur from Tarasoff. So Tarasoff broke the ground on this, but it's actually not the seminal case that we go to. The statute trumps Tarasoff to a certain extent. So, and it came out afterwards. So we don't look to Tarasoff really as the primary authority on this anymore. And what the legislature said is that when there's a threat of serious physical violence that's communicated to the psychotherapist, and the threat is made against a reasonably identifiable victim, the psychotherapist has a duty to warn or protect. which, just like any good statute, raises way more questions than it seems to answer.
Right. Yeah. I have a lot of questions in my head right now. So, okay.
So what constitutes something being communicated to the psychotherapist, and what is a reasonably identifiable victim? Those are the big questions that are raised. And subsequent to this statute passing, cases have gone back and addressed these. So we'll talk about both of these elements in turn. So communicated to the psychotherapist. Typically what we think is a patient endorses homicidal ideation. Doc, I am going to kill my friend today with a baseball bat. That's typically what we think is verbally identified threats, but it's actually both broader and more constricted than just verbally identified threats. So what attorneys engage in sometimes is what's called a synthesis of the law. So they pull in different cases to try and derive a rule statement. So every case kind of introduces something slightly different, and if you combine all of them, then you can get something that approximates what a court should do and what the law is on something. So I've done that in this area. Every attorney is probably going to have a little bit of a different synthesis, but based on the cases I've read, I've created what I think the rule statement is for what constitutes a communicated threat of physical violence. So under a couple different cases that we'll talk about, a few of them, a threat of physical violence is communicated to a psychotherapist when it's, one, verbally identified by the patient, or through other information such as body language or a pattern of severe behavior, which could reasonably lead the psychotherapist to infer that the patient poses a credible risk of violence, or by a contextual member of a patient's mental health treatment team whose communication was for the purpose of furthering treatment of the patient. What the hell does all that mean?
Exactly.
Let's talk about each of the elements, because essentially they're each different scenarios which could arise, which would indicate that a threat of physical violence has been communicated to you. So the first one is being verbally identified by the patient, and that's the classic example of somebody saying, I'm homicidal. Now, merely because somebody says they're homicidal, that doesn't necessarily mean that there's a credible threat of physical violence. The courts have been very clear that on occasion, part of therapy is expressing desires that might otherwise be taboo, but there's no intent behind them. So saying out of exacerbation, I just want to kill my boss sometimes, that doesn't mean that you're going to kill your boss. And the courts have recognized that distinction. Just because it's verbally identified to you doesn't mean that there's a credible threat. The courts have also been very cautious about not imposing undue liability on psychologists here, or psychotherapists. The language the court uses is that they do not expect us to be clairvoyant. Hindsight is 20/20, and so when you look back, you think, well, why didn't the therapist act? You can always find some sort of indications for physical violence that the therapist probably knew about. Merely that because there are some indications, that doesn't mean that there's a credible threat that was communicated to the psychotherapist.
Yeah. So I guess there is some legal protection there. So if we act in good faith to warn someone, if we feel a threat is credible, and the person comes back, 2 weeks later saying, hey, what the heck? Like, the cops rolled up to my house saying they thought I was going to shoot up, at school or whatever. I was just venting. I wasn't going to do anything. But now you've breached my confidentiality. I'm going to sue you. Is that something the client could do? I know you said that we are afforded some sort of leniency within the courts. Is this sort of like a case-by-case basis that the courts would have to determine I guess what standard do they use to say, yes, this was a credible threat, and yes, you were right to breach confidentiality, versus no, a normal person would understand that this wasn't a credible threat and you should not have breached confidentiality.
Right. Well, there's a balance of rights that the patient has that the court is going to engage in. The right of confidentiality and also the right for the therapist to take steps to protect them from causing harm to somebody else. And good faith is kind of a little bit of a wishy-washy standard. So I'm going to use a little bit of a different one. You are not going to be liable if you act as a reasonably prudent psychologist would, knowing the things that you know.
Mm.
So let's just say, a psychotherapist has a hair trigger on these things, and they're calling every other day on all their patients because, I don't know, somebody took a shot of whiskey 2 weeks ago at the bar, and now they're an alcoholic, and everybody knows that alcohol is a risk factor for violence, and so therefore they're going to kill their family. That person can have a belief that they pose a credible risk of physical violence, and they're acting in good faith if they call. They can still be liable for that breach of confidentiality because a reasonably prudent psychotherapist in their position would say, one shot doesn't make you a murderer. One risk factor for violence doesn't make you a credible threat. And there's a difference between somebody having a drink 2 weeks ago and being impulsive and angry and having access to firearms and drinking every day. One's a credible threat, one's not a credible threat, and a reasonably prudent psychologist would know the difference between the two of them. So just because you in your mind believe that you are doing the right thing, that's not the standard that the court holds you to. That's not a good faith defense. But if another psychotherapist would have reviewed all the factors and said, yeah, I probably would have done the same thing, knowing everything that you knew, then you're protected. And that's where it goes back to the documentation, not just what you did, but why you did it, because the why is what the court is going to be looking at. Why is what the experts are going to be looking at. They're going to be evaluating your thought process that led to the decision. And if you have a fair amount of risk factors that you're able to identify, and somebody else would say, yeah, probably in their position, there's a credible risk of physical violence. I agree with the rationale the person laid out, then they won't be liable.
Interesting. So, as far as identifying a victim, we live in fairly politically divided times, and there's a lot of anger going each direction. And I would imagine it's not uncommon for a therapist to encounter someone making threats directed at sort of a general group of people, or maybe it's just rather ambiguous, with no specific person in mind necessarily. If they're making some sort of threat in that regard, is there still a duty to warn? And if so, who do you warn? And I guess, does it really have to be specific to an individual is the overarching question.
Well, I'm going to hit you with the classic attorney, it depends. So that goes to two different elements, whether or not there was a credible threat of physical violence that was communicated, and whether or not there was a reasonably identifiable victim. And we'll get into a little bit the reasonably identifiable victim. A reasonably identifiable victim can be a group of people, but it has to be a reasonably identified group of people. If you say Democrats, well, that's 50% of the population. It's pretty hard to warn every single Democrat. But if there is an insular group of people, there's a quantifiable number, you can reasonably identify them, then a group of people could be a reasonably identifiable victim.
And then, so there's going to be a rally down on Main Street 2 nights from now, and I'm going to go there and I'm going to, show them what's what, or, whatever they're going to say. I don't even want to say how horrible some of the stuff is, but if someone makes some sort of threat about an identified group of protesters or rally goers or activists or whatever, is that, where's the duty there? Is it to just alert law enforcement? Is it to alert the organizers of the demonstration? Or is that even identifiable enough to breach confidentiality and go warn? Does that trigger the duty to warn if it's a rally like that, for example? And I know I'm putting you on the spot with this specific case, so I apologize, but just kind of curious.
No, so you're bringing up an interesting point where there's a little bit of a disagreement or some tension. I called it the duty to warn / duty to protect, because different people call it different things because they think that there are different duties that are present here. So, for example, some people have argued that your duty really is to make sure that the public is safe from this credible threat, or this reasonable identifiable victim is safe. And so, if instead of warning, you increase the dosage on your psychotropic medication, or increased frequency of psychotherapy contacts, or you put them in an involuntary hospitalization setting, you've taken steps to protect the public. And so even though you haven't warned them necessarily, your duty has been discharged. Other people say, well, Karasoff is the one that established this statutory right, and under that, they were required to warn the victim, and that's what they were held liable for. So you should warn the victim even if you take these other steps. And the complicated part of this is that the duty is established by your community of individuals in your field. So we're talking subfield specialization and geographical location.
Oh, interesting.
So, for example, yesterday, I was dealing with a patient who was in segregated housing in a prison. And he was saying that he was homicidal, and he was agitated, and he was evidencing some symptoms of mania, which were all problematic warning signs for violence. And I can infer, based off of his communication with some of these CEOs, that they were probably a reasonably identifiable group of victims for these vague homicidal threats. Now, how I handle that in a RU setting, a segregated housing setting, and how somebody in private practice would deal with all those risk factors is going to diverge significantly. And the prosecution technically could get an expert from, psychoanalytical theory, where they meet with the patient every day for multiple years and get that person to testify and say, hey, obviously, all these risk factors, you should have warned every single CO in that building. But what I would argue in defense of myself is that that's not my subspecialty. That's not my geographical region. What I really should be judged against is other psychotherapists within the prison system who deal with this population. And we have a very different approach to dealing with some of these things than somebody would in private practice. So I'm judged against the standard of care for my particular subspecialty, even though the other person could technically bring in these other experts. The court would find it weaker evidence than would an expert in management of prisoners.
Interesting. Actually, on the topic of expert witnesses, is there any legal protections as an expert witness? If you get called to be an expert witness and you share your opinion, and if that opinion somehow impacts the defendant in some way negatively, or I don't know, or maybe it drags on the case and it turns out that your opinion was overridden by other experts, or I guess, is there any legal liability that you can face as an expert witness? Or is it strictly, this is your opinion, you're vetted as an expert, so your opinion is considered valid, and you don't have any legal ramifications possibly by acting as an expert witness?
So even as an expert witness, you still have duty breach causation damages. And if you breach that duty and you don't hold yourself to the same standard as other expert witnesses, which is a subspecialty, would in a similar situation, and that causes damages, sure, you could have a theory of liability. What I will say, in a corollary scenario, there's been psychotherapists who have been retained by the court in family law. And family law is one of the areas that's most contentious and most likely to result in an ethical complaint. Nobody's ever happy with the psychotherapist
Mhm.
who makes custody recommendations. And the court has been very reluctant to hold those experts liable because they're essentially asking for their services. They're saying, hey, you can help us kind of make sense of this case. The court's not going to then turn around and say, I know I asked you for this job. You did a terrible job. I'm going to hold you liable. It's a tough position for the psychotherapist to be in already,
Mhm.
that the court kind of recognizes all the tensions and isn't going to turn around and impose liability on them. They've been reluctant to do that. There can, of course, be gross negligence, but because you're helping the court has kind of been reluctant to impose liability on those people.
I see. So while there may not be any statutory legal protection, it's sort of inferred in a way, to an extent.
In practice, it has been, yes.
Understood.
Yeah. Okay, so I'm going to go through a couple of cases for this duty to warn / duty to protect to identify like the verbally communicated to patient or through the body language or from somebody else. So Caldron v. Glick, there was a gunman who shot and wounded 6 total members of a former girlfriend's family. And in the therapy sessions, the therapist knew that this individual was very upset with his former girlfriend, but he didn't verbally identify any threat. Very crucially, what made this case interesting is that there wasn't any fluctuations in the person's body language, which indicated a potential for violence. So the therapist asked, do you want to kill your girlfriend's family? And the person looked dead in the eye and said, no, I don't. Now, they can lie to us, and if we can tell, regardless, that there is a threat based off of the history, based off of risk factors, based off of body language, that can still be a communicated threat. So let's just say you're in the same situation. The person you ask, planning to kill your former spouse, and they go, no, wink. Verbally, they said no, but their endorsement of homicidal ideation is not dispositive, is not the end-all and be-all of this factor. They can communicate through other means, including history, including body language, including risk factors. So it's the totality of the circumstances rather than verbal endorsement that matters.
So this was case law, correct? I forgot what you said the name of the case was, but how, just out of curiosity, in that specific case, how do they prove that there was body language demonstrated that would suggest that there was a legitimate threat despite what the client was verbalizing?
Testimony, discovery, therapy notes.
Okay.
We have to do an MSE. Well, we don't have to do, but it's best practices to do an MSE in all of your therapy notes. And if you document, that the person was agitated and refused to make eye contact when posed questions about homicidal ideation, and was pounding his fist against his other hand in the entirety of the session, red in the face, but denied homicidal ideation, that doesn't mean that there's not a risk.
Mm-hmm. Interesting.
Yeah.
Wow. Yeah, body language. It's a biggie.
And again, don't hair trigger this matter, but some psychotherapists tend to live or die on the hill of denied ideation. And that's not what the court looks at. And that's not what you should look at when you're determining the risk. The presence of ideation doesn't mean that there's a risk. The absence of endorsed ideation doesn't mean that there's not a risk.
Wow. Wow. Yeah, it gets pretty complex.
Yeah.
Wow. Okay.
So on this same vein, there was another case decided 2004, right around this other one, Ewing v. Goldstein. An individual was housed in a inpatient psychiatric center for danger to others. And to the treatment team, he seemed absolutely fine. He was being prepared to be discharged. However, the patient's father called the treatment team and said, hey, I want to let you know that he's telling me that he wants to kill his former significant other. The psychotherapist went and asked, is this true? And the patient said, absolutely not. Me? I would never. In that scenario, the person was released and they went out and they killed their former significant other. And the court ruled that that third-party communication should play a role in the determination of whether or not there was a credible threat. So again, we have a denial of homicidal ideation, but we have other information that proves that there might have been a risk. And the court is going to weigh body language, third-party communication, risk factors for violence to determine whether or not you should have known, or a reasonably prudent psychologist in your position would have known that there was a credible risk for physical violence.
Interesting. And I have a question that might be a little out of your wheelhouse, but maybe not. My understanding is that if one person works for an institution such as the VA, California Department of Corrections and Rehabilitation, Department of State Hospitals, any big entity like that, there is a level of protection afforded to you by working for a government agency like that. But that doesn't mean that you're fully protected. You could still be personally sued for negligence and damages that you may cause. And so is that correct, or are you fully enclosed under the institution's umbrella and protected? Or again, this might be out of your wheelhouse and it might be institution by institution, I don't know, but legally, are you still personally liable for any harm you may cause from failure to act or various duties to warn?
The answer is yes, but. So yes, an attorney can bring a suit against you personally for your actions, even if you work for the federal government or the state government. However, we're a pragmatic bunch and we look for deep pockets. We want to make sure that there is sufficient money to cover the compensatory damages that we believe our patients should be awarded. And sure, maybe we can prevail against you, but you have a stick of gum and two stale loaves of bread at home, and that's all you got. You got nothing in the bank account. We can get, a $5 million award against you, but it doesn't matter because you're not going to be able to pay it. So what we do in scenarios like that is there's a doctrine called respondeat superior, which means if you're working at the direction of another agency and the action that was alleged to be negligence was conducted as part of your duties, that the employer can be liable for your actions. And I'm willing to guess that the federal government probably has a little bit more money than you have. So we are going to be going after federal government. We can, however, sue both. And in the malpractice suit that I'm currently litigating, we are. Because the physician in question has significant assets. We can do an asset search and determine exactly what you're worth. And we can go after the hospital under the person who the person was working for. And we can recover from the total amount of money from both. So just because we're more likely to go after your agency doesn't necessarily mean that you're fully protected, but you are less of an enticing target.
That makes sense. And again, I hope I'm not asking a question that kind of puts you on the spot, but so if I have a private practice and it's an LLC, am I protected from liability from that, from this point of view? I know that affords some sort of protection from personally being sued, but as far as if I'm practicing as a psychologist within an LLC, am I still protected from malpractice for this? Or I don't know if malpractice is the right term, but this duty, this responsibility, am I protected from that under an LLC or not so much?
It depends. So it depends on the primary thing. It depends on is a couple things, but the primary thing it depends on is how distinct you keep this LLC from your own personal finances. So there's a doctrine called piercing the corporate veil under business law, where essentially people can't hide behind shell companies. If you have intermingling finances, it's very easy to open up an LLC. It's a pretty much a single piece of paper that goes off to the Secretary of State, and then boom, you are a business owner. So that process is easy. But if you function separately, your own personal life and the LLC, you're going to have a better case to say the company is not me. You should sue the company. But if you keep a single bank account, if you just kind of deposit any money that comes in through your LLC into your personal finances, withdraw any expenses that your LLC might need from your personal budget, there's going to be a case that says, Your Honor, this is a sham corporation that this person can't hide liability from.
Wow. Okay. Okay. So it's all about intermingling of funds and okay.
Yeah, it's a very important factor. Yeah.
And then really quick, so as far as what we're talking about, I know you had your disclaimer on the outset that this is not legal advice. This is just informative. These duties to warn, is this federally mandated? Is this a state by state basis? I know, I'm sure Tarasoff is well known. Everybody talks about that in grad school, all day long. And so I assume that that's nationwide. But the legal standards for duty to warn, duty to protect, is that set by the state board or is it a federal mandate?
Mm-hmm. So I haven't looked into the federal law behind whether or not there's a duty to warn. I'd be very surprised if there is. Typically the tort law, just basic tort law, which what we're talking about here, negligence actions and malpractice, is generally governed by the state. Each state sets their own standards. For example, California has certain caps on recovery, which have recently been increased a little bit because they were first set decades ago. But those matters are typically governed by the state. Same with the state board. The state board can set standards, which an aspiring attorney can then look to see if there was a duty and a breach of the duty. But merely because something was prescribed in the ethics code doesn't mean that there was necessarily a duty. And vice versa, just because it's not in the ethical code doesn't mean that you should be doing something that you're not doing. So it's probative evidence of what the standard of care is, but it's, again, not the end all and be all.
Awesome. Okay. Did we get to all of your talking points that you wanted to bring up today?
We also have the reasonably identifiable victim.
Oh, let's get there. Yeah.
Okay. This one I think is slightly more interesting than the last one. So what is a reasonably identifiable victim? In the Tarasoff case, the psychotherapy client never identified who it was he was talking about, but based off of all the conversations and the context, they knew that it was probably this one woman on campus. But you don't even need all that information to be a reasonably identifiable victim. So again, creating a synthesis of some of the case law, I believe in California, that it's reasonably identified when the person is verbally identified by the patient as the intended victim. Right? It's Bill Williams, he lives at 423 Main Street. Pretty easy, pretty simple. Is readily identifiable based on the patient's history. That would be the Tarasoff scenario, where there's a history of this individual being spoken about. It was known that there was the person of the object of the person's focus, or reasonably identifiable based on the likelihood of proximity to the intended victim. So let's talk about Barry v. Turok, which is probably my favorite case in all of this. In 1990, there was an individual who did not speak English. He was on the 7th floor of a hospital. He, I'm not exactly sure what was going on with him, but he had a tendency to be sexually assaultive to the female staff on that floor. He would grab them, he would kiss them, he would fondle them. But because he didn't speak English and nobody was communicating directly to him, he never made any verbal threats of violence during his stay. During his stay, there was a victim who worked on the 7th floor, and she was in her office alone when this patient made it to her office, and sexually assaulted her. And that woman brought suit against the physicians in the hospital, claiming that she was a reasonably identifiable victim. She was a female on the 7th floor, and there was a pattern of violence against females on the 7th floor. The court held that she was a reasonably identifiable victim. It ruled that the psychotherapist has a duty to warn a third party when the third party is reasonably identifiable, and that because she was a female working full-time on the 7th floor, that she was a reasonably identifiable victim. So why this is important is because, Dr. Stack, you and I have both worked on units in a psychiatric hospital where individuals had a history of both sexually inappropriate behavior and violence towards certain people. So let's just say that somebody on your unit is very reactive to a particular ethnicity. They have delusions about it. They believe that everybody who's white is out to get them. Particularly, let's say white bald males, because he thinks that the skinheads are gonna get him. And he's assaulted a few guys who have been bald, who have been white, who have come on the unit. And you know this. You have a duty to warn/protect any individual who comes onto that unit who's about, who is bald and Caucasian. And it's not verbally identifiable, but you can make a pretty good assumption that that person might be a victim of this person based off of the pattern of behavior.
Interesting. Very interesting.
So we do things like morning shift change, afternoon shift change. We document the risk in the treatment plan. We put things in the Cardex that people show to people who come onto the unit to demonstrate and communicate this risk to people who come on, so that you're bald and you're white and you're working on this unit, probably not best to hang out with him alone. So this reasonable identifiable victim is when we get to your question about the protest downtown. It's a group of people that you might not be able to say, sure, it's Bill, Ted, and Susie, but pretty much who this person might target, and you have a duty to take steps to protect those people.
So how do you ensure that you're carrying out that duty responsibly, going back to, again, the protest, and maybe you don't have those names specifically? Is it just contacting law enforcement, or
yes?
How do you?
So it goes back to what a reasonably prudent psychologist would do in your situation. And this is why consulting is so important. Because remember, this standard is based off of your geographical and practice areas. So if you consult another psychologist who's, let's say, in the same private practice, dealing with the same patients, and they say, hey, I would do X, Y, and Z, and you document that and you follow their instructions, that is another reasonably prudent psychologist who is in your same domain and geographical location. And so you have a very strong case to say, hey, I am following the standard of care in my general area because I received advice from somebody who's a reasonably prudent psychologist dealing with my subspecialization in my geographical location. There's evidence that you sought out the standard of care, and then you followed the standard of care.
Again, the importance of documentation. It's so important in our practices.
If it wasn't documented, it didn't happen. I think everybody knows
exactly that. Yep. That's the old expression anyway. Wow, this has been really eye-opening, Dr. Morrow. Thank you so much for being here and sharing all this information with us. I think that's going to conclude our episode, or this episode of Licensed Ally Expert Series. You will now be provided instructions on how to log your self-directed learning CPD hours into licensedally.com. And thank you again, Dr. Morrow, for being here. To log your hours for this episode, go to licensedally.com and click on Start Tracking Your Hours. From there, you can sign up for free by clicking the sign up link. Your first 6 activities are free to log on licensedally.com. If you're already a member, feel free to just log in. Next, click on the Log New Activity button at the top of your dashboard. Select Academic from the Category drop-down menu. Select Self-Directed Learning from the Activity drop-down menu. For the title, please type Licensed Ally Expert Series, Duty to Warn, and Malpractice. Under the description field, please enter a brief description of the video you just watched. Then enter the date that you watched the video. Since this video is 1 hour long, select 1 hour from the drop-down menu. Because this video pertained to laws and ethics, we can select Laws and Ethics from the optional topic area drop-down menu. Now click on the Save Activity button and your activity will automatically be saved to your dashboard. You will get a small pop-up at the bottom of your screen confirming that your activity was saved. Thank you for joining us for this episode of the License Ally Expert Series.